Hi guys, welcome back to my channel, The Sea of Regulation. For those that have subscribed, a huge thank you. And today I'm back with another video. I am going to be talking about some of the key areas that regulators tend to focus on during their on-site inspections. So if you ever wondered where we tend to focus the most, this is the video for you. Now before I dive in, let me get the usual disclaimers out of the way. I am a financial services regulator. I am not a lawyer, I'm not a financial advisor, and nothing on this channel represents the views of a financial services regulator or an international standard setter. So with that out of the way, let's dive in. So guys, it's useful to understand what regulators tend to focus on when we come to conduct an on-site inspection. And there are a few areas that intrigue us to see whether you've really gotten this compliance thing right. And I can tell you off the bat that there are some hot spots that we tend to be able to get into and find deficiencies. These are some of the areas that also attract the largest fines. So you definitely want to stay tuned. So I have a list of 5 areas and we're going to go right straight to the first one: customer due diligence and enhanced customer due diligence. This is also known as know your customer. And it is one of the critical areas that we find deficient in a lot of institutions that we inspect. People don't necessarily understand what they need to collect, how often they need to collect it, what should be maintained on file, and there's an added layer to what due diligence you conduct. It's attached to your risk assessments. Knowing exactly what information you need to collect in relation to due diligence is tied to your risk assessments, and that has to be captured within your manual. So if your manual is deficient, sometimes that leads to a problem as well. But it is one of the areas that regulators tend to scrutinize the most. So if you want to win at compliance, one of the areas that you definitely need to get right is customer due diligence and enhanced customer due diligence, and also your risk assessments. So a little bit of both. The next area that regulators tend to look at are your sanctions handling and your handling of issues surrounding proliferation financing. Now, what is that? I don't want to get any kind of flags from YouTube, so I'm going to put a definition in the comments below. Sanctions are dissuasive measures that are put against individuals, countries, organizations that have known issues. And again, that's something that I'll put in the description below. But why is it important for regulators to look at issues of sanctions? You're not facilitating certain nefarious activities. You're not facilitating sanctions breaching. And even if you're in a country, so another good example, if you are in a jurisdiction, say in the Caribbean, not Puerto Rico, not the US Virgin Islands, and you are not paying attention to US sanctions, it can still be a problem. Why? Because you kind of need the US for cross-border currency trading. So even if you feel that certain sanctions that are issued by certain countries do not apply to you, here's a quick tip: they typically do, and you should be paying attention to whether you have clients that are breaching sanctions. In relation to proliferation financing, one of the areas that I think people get wrong or completely overlook when they're looking at their clients are dual-use goods. So for example, you're a trust company and you have a client that wants to incorporate a company for medical practice. They are an oncologist, so they treat cancer. And oncologists and cancer research centers tend to use certain materials that can be used for other purposes. And that is what is called a dual-use good. So the goods, the raw materials that they need to do the radiation therapy and the chemotherapy are typically quite dangerous if they get into the wrong hands. And if you don't understand the risks that are attached to that customer's business and the potential risks, then you could be facing some different issues. And again, these are some of the things that we see firms may not think of, and as regulators we go in and we assess these things, but here's where I'm here to help. We come in, we see these things, but from my perspective, I'm going to clue you in on some of the things that regulators look at, and this is definitely one that's going to gain a lot more attention. Another area that regulators tend to focus on is your record keeping practice and record retentions. So how are you recording your information? Are you documenting properly? Are your files maintained in good order? And more importantly, when a relationship with a client is over, are you retaining the records? It's critical to maintain those records. And at times you have to maintain them for 5 or more years, depending on the laws of your local jurisdiction, just in case there's an investigation that needs to be done on those records. And if you've destroyed those records, or the records are maintained in a manner that doesn't allow for even a law enforcement authority to carry out their investigations, you're going to be in a lot of hot water. So again, it's one of the areas that regulators scrutinize. If you want to win on compliance, make sure your record keeping game is tight and make sure your record retention periods are in keeping with your laws. Another area that we look at during inspections are how you deal with suspicious transaction reports and suspicious activity reports, and your engagement with the reporting authority. Now, one of the challenges that regulators have seen is that everything is great until it's not. And these suspicious activity reports and transaction reports are just not filed until something happens. And by then it's usually too late. It says to us that you may not know the business of your clients that well, your monitoring systems are ineffective, and what we see are a lot of reactionary filings. So you wake up one morning and your client is in the news for corruption and bribery and embezzlement, and there's money laundering, and all the wrong things are happening. You get into the office and immediately SARs are filed. It doesn't help then. And usually in retrospect, I mean, hindsight is always 20/20. In retrospect, firms do realize that there were suspicious things going on, but they chose to ignore it. Reasons can be wide. It could be just ignorance. They just didn't understand, and maybe they needed more training. Or it could be that, the client was quite charismatic and lulled that particular service provider into a state of comfort. Whatever the reason is, if you're not doing it properly, it won't go down well for you, especially if it's found out, not necessarily during an on-site inspection, but during a fraud or financial crime investigation. It tends to be very painful. So this is one of the areas that you need to make sure is tight in relation to your compliance measures. Now, the fifth area, I told you that there were 5 areas. The fifth area is your outsourcing of certain functions and your engagement with third parties. Now, this is a ticklish area. Certain firms outsource things because they want to maximize on the limited resources that they have, and instead of hiring a dedicated person or team, they would outsource certain functions to individuals or companies. But at the end of the day, you retain the responsibility of that thing you've outsourced. And regulators are increasingly focused on making sure that there's clarity in terms of how you should outsource, what you can outsource, and what controls you should put in place to make sure that you are not found wanting. Because it doesn't do you any good if you need something from someone you've given responsibility to, and when the chips are down, you ask them for that information, and it's like, oh, sorry, I can't provide it, or they're not responsive, or they've been arrested. I mean, these things happen. And your engagement with third parties, I'm not saying that you're not supposed to have business relationships with third parties, but remember that in certain instances, when the chips are down, sometimes they are looking about their self-interests and not necessarily your own. So it's one of the areas that you need to scrutinize. You also need to risk assess. And you need to make sure that you have very robust agreements in place, because it's one of the areas that I think a lot of false comfort is put into different institutions, even other regulated institutions. A lot of false comfort is placed in the hands of third parties, and too often, it's not in every case. There are cases where it does work, but too often it can go wrong. Now, I know I said 5, but thank you for sticking with me so long. I do have a bonus. The 6th area that you need to focus on in terms of making sure your compliance game is tight is cybersecurity and your business continuity plan. So maybe 6 and 7. Cybersecurity, I can't say enough about it. I have been on the regulatory side of a lot of issues where there have been breaches in security and records accessed. And it's painful for the firm. Of course, there's reputational damage, but there's also a compliance cost in the end. And in compliance, a lot of persons will focus on training staff, and senior management, IT staff also need to be a part of the compliance framework. It's critical for your cybersecurity game to be tight. I mean, we're seeing more ransomware attacks in the news right now, and it's not by accident. The world is, going through a lot right now, and businesses are struggling, and there's certain players, bad actors that will seek to attack a firm just to make a quick buck. And as it relates to business continuity planning, this is something that, again, impacts everyone. I live in a place where we dodge hurricanes from June to November. And not every year we're lucky to dodge the hurricanes. We've had some direct hits. And if you have business disruption, you need to have a plan in place to make that disruption as minimal as possible. And it doesn't have to be from a hurricane or a forest fire or a flood or a blizzard. I mean, there's so many issues that can happen. So your business continuity plan is essential. And on a macro scale, when we're looking at global financial stability, it's important that firms have measures in place to allow them to continue their operation. But a cybersecurity attack can be just as devastating as a hurricane, flood, or earthquake. So this is why I have the two of them together. But if you can think of something that you tend to see regulators hone in on, drop it in the comments below, because I'd be interested in hearing your views. And I'm definitely coming back with some more content around inspections. I have my course out now, and I'm thrilled about that, to help everyone figure out what they need to do to get their compliance game right. Definitely stay tuned for more videos. Like if you enjoyed this video, and make sure you subscribe and hit the notification bell, because I'll definitely be back with more.